Okay, did you take any action, Ms. Novak, after you believed you were being somehow not supported by the secretary, once hearing about these newsletters? Did you take any action to talk to anybody in the administration?
I talked to Doug Percy, if that counts as administration. I didn't talk to anybody in the secretary's office.
Okay. I'm going to allow her to discuss what, if anything, she had a discussion about these newsletters with Mr. Percy, but not to prove that that's what the secretary said. We have the secretary's testimony to the extent he remembered about what happened in this meeting. The complainant wasn't there. We have the newsletters. We don't know how accurate they were. So we're not going to allow those in. We're not going to allow her to testify about what she thinks she said, unless to the extent she told Mr. Percy. So go ahead.
Well, but so maybe I can make an argument now, Judge. Would that be
okay? Go ahead. What do you think?
Okay, I appreciate that. It's always a good opportunity. So here, the fact is that what he's doing is saying it wasn't admissible because it's what Carr didn't say. Okay. Well, so now we're bringing it in for how she received it and whether or not she received it and what it meant to her. And so if other wardens are sending it to her saying, I can't believe this is the case, and she's reading it, it's important to assess whether or not this is part of a message to her that she is going to be subject to some kind of different discipline or that her termination is imminent. And it goes to that question precisely as to what was in her state of mind, what an ordinary employee would think when they're presented with these disciplinary charges of gross negligence after the secretary makes this statement saying that if I find her doing a work rule violation, then I'm going to terminate her. So that's why it's relevant. Thank you for asking.
Okay, and I think that I'm allowing that part it into exactly what she talked to Mr. Percy about and how this affects things. Her belief about things isn't necessarily, I mean, we're talking about what happened really with the termination. I'm allowing this ancillary thing in about this to the extent that it shows anything about how the secretary did view her. But again, we have the secretary's testimony about what happened. We don't have anybody else from that meeting. The complainant was certainly not there. And I don't believe any of those other wardens were there. And you don't have those wardens to testify. So we're not going to talk about
what we have is the document by those authored by the people who were at the meeting saying.
And I told you I'm not letting that in because you didn't authenticate it. So no, that's not coming in. No.
Okay. So
okay, so Miss, you can ask have Miss Novak testify if she wants to about how she, how she then reacted.
So I'm going to quote Rutherford here, and I'm going to be clear that Chapter 227 of the stats requires very relaxed rules of evidence for administrative hearing. An administrative law judge is directed to admit evidence of reasonable probative value and should exclude only evidence that is immaterial, irrelevant, or duly repetitious, or evidence that is inadmissible under a statute.
You're not going to listen to my ruling. I have given you the opportunity to talk. I have decided the issue. Your job is to then go on, continue on, and again, if necessary, in the future, you will have the right to appeal that and again say everything you want to say about why I was wrong. I've already decided the issue and we're moving on. You're not going to change my mind by going on, and it's inappropriate, and I want you to stop.
By citing an appeals court decision. Go ahead. By citing an appeals court decision, I also need to put on the record here, again, that you made this decision prior to hearing any input from our side. That's no wonder my client tried to get her side in because, again, you heard from Mr. The state, then made your decision, then you allowed me to put in what I had to say, and then went on with your argument here.
Okay. And I apologize. I should have let you in, but I figured I didn't know.
Excuse me. I'm trying to put something on the record and you're interrupting me.
Right.
I'm saying again, this is a Court of Appeals decision that's directly opposite to what you're saying. I'm trying to cite that and put that on the record. While I was doing that, you
I'm fully aware
interrupted
of
me. And
Rutherford.
excuse me, as you're doing now, you interrupted me and threatened to mute me. So
I will
that's
mute you if you stop.
problematic.
Let's stop now. I told you to stop, and that's my direction. Stop now. If I'm wrong, again, you get an appeal, you can have me overturned, whatever. Let's move on. We got to get this hearing done.
This is the second time that you've muted or
Stop
threatened to mute me
now.
when I'm citing
Stop
the law.
Now, stop now. My direction is to continue with the examination.
Which we're happy to do. The problem is that when I try to
No,
make my record,
You
I
do
get
not get to
interrupted.
continue the filibuster. I've told you this before. I make the ruling. You don't like it. You've had an objection. You can make all the arguments you want on appeal if necessary. That's the way this goes. I make rulings, the parties live with them, I live with them, and then if it doesn't work out, I mean, for whoever it doesn't work out with, they may be appealed and the issues may be changed on appeal before a different body who thinks that the decision should have gone some other way. I live with that, you live with that. Everybody does in the legal system. And that's what you need to do as an attorney, is to respect my decisions and move on. And then in the future, show if you believe I was wrong, why I was wrong. Let's move on.
So the way that I preserve those issues for appeal is to put them on the record, which is what
I am
have
not
been
going to allow
trying
you to
do,
continue. No, you've
but I
already
keep
put them
getting
on the record.
interrupted.
You have put them on the record already. And your statements have been very clear throughout these proceedings about your beliefs about why you think more things get to come in than what I agree with. And I have let you talk, and we are not going to continue. You can put them again on the record. You can talk about it on appeal if it's necessary. Go ahead. Continue with your client.
So again, I can't even get my objection that I'm trying to make.
We are
out,
not
that
going
by
to continue
not
this way.
allowing
Do
me
you
to
want to
put
take
my
a break?
objection
I
on
will
the
take a
record,
break
you're
so that you
violating
can
my
calm
client's due
yourself
process
and get
right.
yourself in order to follow my directions. That's it. That
I
is the ruling.
understand your direction. I'm happy to comply, but I need to be able to put my objection on the record without you interrupting me, which doesn't seem able
We
to
are not
happen.
going to have this. Stop. Ask the questions. Your record is clear that you disagree, and I am fine with you disagreeing, fine with you making appeal, arguments if it's necessary. And at this point, we just need to continue with the direction, the examination of your client so we can get this hearing done. So move on.
So, how did you receive this message, what message did you receive from the article when you read it?
I'm going to object again. Again, we're talking about the substance of an article that the authenticity and the foundation hasn't been laid.
I have told you that I said that she wants to tell us about what she talked to Doug Percy about, because she did then report it to management. I assume that will come out in her discussion with Mr. Percy. So let's move on to that.
Right. So in order to get to that, I want to know first what she received from this article, and then we'll get on to what she communicated to Mr. Percy.
as long as she's not going to talk about all the things, all of her feelings. And again, her feelings aren't necessarily the issue. The issue is what did the decision maker think? And to the extent that I think she
Not in
may
the
have
constructive
taken
discharge
action,
case.
yes, well, a constructive discharge case, okay, but then you can bring that up at the time that she was constructively discharged, or which she believes she was constructively discharged. So.
Sure. So, but that would then say
Okay,
that the only
all right, Mr. Cross, I will allow you to ask her this question. I don't want too much about what the alleged article said. Okay, go ahead.
Do you understand the question?
Me? Yes.
Yes. Can you please answer it?
Yes. I was shocked when I saw it. I've never heard anybody say that about an employee, period. I mean, as a warden, I don't say that about my employees. I don't have the power to just fire anybody when they violate a rule. There's due process. There's progression of discipline. It's not even an accurate statement. I mean, I wouldn't say that about an officer or a social worker. I was shocked to see that put out to the public.
Okay. And did you believe also, I mean, was there anything about progressive discipline? I mean, let's put it this way. Did you believe that if you violated any rule whatsoever, you could be terminated according to those statements?
Absolutely. He wouldn't say that if he didn't mean it. You're not going to turn around then if I did violate a rule. How do you turn around and not fire me when it's put out to everybody?
Okay. Do you believe that inmates in Columbia Correctional Institution received this communication or
Yes,
article?
I know they did.
How do you know that?
Because it comes in either through the mail or electronically on their tablets, and the mailroom staff had brought it to my attention. Everybody saw it.
Did any inmates bring it to your attention?
Not that I recall.
Okay. But this is when you say everybody, we're talking about Department of Correction staff within the institution.
Yeah, they handed it out. They know the inmates got it. I'm sure there were comments, but not directly to me from inmates. There were comments to me from staff.
Okay. Did after you received this article that you talked to Doug Percy about the article?
Yes, because I was angry that it was
Okay.
out there.
And just to be clear, this is your normal way of communicating with the secretary is through Doug Percy, right?
Yes.
Okay. And so what did you communicate to Doug Percy?
I asked if he had saw it. I don't remember what his reply was, but I had him look it up online, looked at the website. It was there. I didn't get a response from him. I got I don't know. I don't know. He wasn't going to go to bat for me. I wasn't going to go to the secretary and say anything. I didn't believe he would.
And do you believe that the comments that Ms. Fesahai made to you about her meeting with this group and what was reported by the group were the same?
No, that's not I don't take that. My opinion is that's not a supportive comment. That's not how you support your staff.
Okay. And that's, again, in distinction to how the attitude towards you from the prior administration, is that fair?
Exactly. It's the attitude, the training that how I present my employees. I've been questioned the same way from media and groups about my employees. I would never answer that way. Because it locks you in. You say, I'm going to do this, then you're locked in. And you can't do it. That's the bottom line. You can't just fire somebody for a rule violation.
Okay.
But I guess you can. With this administration, I guess you can. It's not supposed to happen, though.
And I just want to back up. When you became warden, were you surprised at all about how much authority you had?
The opposite. I was surprised about how much authority and decision-making ability I didn't have.
Why?
Because you hear it all the time. It's the warden's institution. They're the appointing authority. They're the head of the institution. That's everybody's perception. when I got into that position, I realized how often I had asked permission for everything. It was very rarely any decisions I could make on my own. It was very surprising.
Okay. So with that knowledge in mind, I mean, is it fair to say you believe the secretary was making most of the decisions?
Of course, I know he was. We had, during our warden meetings, he didn't hesitate to say, wardens only make recommendations. I'm the decision maker. The buck stops here. I can tell you, I heard that on at least 2 to 3 occasions.
Okay, and did that factor into how you perceived what you had perceived from that article?
Yes.
Okay. Now, about how many months was it from the end of the lockdown to the escape?
About 3 months.
Okay. And were you during the escape, did the administration send anybody to assist you in any way?
They said they did. Magda said she was sending Security Chief Larry Fuchs to assist me.
Okay. And did you believe that that was unusual in any way?
Yes, well, she told me that before I even got to the institution when you're trying to organize everything. But as the day went on and there were so many components and aftermath and things to do, you know, I realized after, you know, that later that day or the next day, maybe, you know, he wasn't there to help, nor could he. I don't believe he could help me because he had never been a warden. He'd never been a deputy warden. The highest rank he held at an institution was security director.
Okay, and can you
That's
just
number 3, and that's very, very different. There's a huge learning curve from number 3 to number 1. A million more job duties and responsibilities. There's no way to even compare that. So to send him there to help me, which again, I think I already said, he was there to report back to the administration, to ask me questions. He wasn't assisting. We have 36 institutions. They couldn't have found a warden to come to the institution to assist. I don't understand why they picked a security chief, other than they knew him very well. He had an office down the hall from them. I don't know.
well, did based on your time as an investigator and as a deputy warden, as a warden, do you was it the normal practice to send a security director to go to assist with a major incident like an escape?
No, I had never seen that.
Okay. And we've heard some testimony about this checklist, and I believe you've testified about this checklist before. Or do you recall that?
Yes.
Okay. Did Mr. Fuchs assist you in completing the checklist in any way?
No, not to my knowledge.
Okay. Did I believe you testified that he stuck his head into your office from time to time, asking for updates. Is that fair?
Yes, that's what he did.
Okay. Did he help support you in any other way?
No.
Okay. And then we also have that he participated in the security review of the escape, right?
He participated in the hourly meetings. He also participated. Are you talking about the after action review?
After action report. Thank you for that. Yes. And that his somebody that he knew, somebody that he picked was chosen to author that after action report, right?
I'm going to object to that. It assumes facts not in evidence that he picked Kevin Garceau.
Sustained. Sustained. Go ahead.
So then, And that's also the after action report that you asked about but weren't able to, nobody consulted you on, right?
Right.
Okay. Now, during the escape, were you talking to other wardens at maximum security prisons?
Yes, during, you mean like right after the escape?
Yeah, right after. That's fair to say. Thank you.
Yes, I mean, like I said, I was very busy. I don't think I spent much time on the phone those first couple days until we had apprehended the inmates. But yes, on my way into the institution that day, people were calling to give support, ask what happened. In the days that followed, they did.